dengan. Kami Ikatan Advokat Indonesia menjunjung tinggi kejujuran. Kami Ikatan Advokat Indonesia berjuang demi keadilan. Kami Ikatan Advokat Indonesia rela berkorban untuk bangsa.
Assalamualaikum warahmatullahi wabarakatuh. Selamat sore, salam sejahtera untuk kita semua. Selamat datang kepada narasumber kita hari ini. Welcome, Mr. Philipp Kersting. Good afternoon, sir. Did I pronounce your name right, sir?
Yes, perfectly fine, thank you.
Okay. Thank you for your willingness to be a speaker today. This is the first time of our event to invite a foreigner speaker, sir. Sir, before we start, just to make sure, will you present in English or both in Bahasa and English, sir?
First of all, thank you for having me. I'm honored to be the first foreign speaker here. I do speak very simple Bahasa Indonesia quite okay. So I will present the slides in English if you allow me. If anyone wants to ask questions in Bahasa Indonesia, I'll be happy to try. I guess I can count on your help to translate if I don't understand. And I will also try to answer in Bahasa Indonesia, no problem. I'll do my very best.
Okay, thank you, sir. I'll introduce this event both in Bahasa and English. Sure. May I start, sir?
Sure, please go ahead.
Okay. Selamat datang juga kepada Bapak Ibu peserta acara Legal Upgrade episode 9 dengan tema Introduction to German Legal and Judiciary System. Kita akan mendapatkan ilmu baru tentang sistem hukum dan peradilan Jerman. Sebelumnya, perkenalkan saya Ina Syahira yang akan menjadi moderator pada Legal Upgrade hari ini. Kembali kami infokan, Legal Upgrade ini merupakan program kerja Ikadin yang berbeda dengan Legal Update, di mana Legal Update membahas isu terkini dalam perspektif hukum, sedangkan Legal Upgrade merupakan pendidikan hukum berkelanjutan bagi advokat Ikadin, atau biasa disebut dengan Continuing Legal Education. Sir, Legal Upgrade is a program by Ikadin, which is a continuing legal education for Ikadin's lawyer. Kita akan segera masuk ke inti acara dari hari ini, yaitu penyampaian materi, namun sebelumnya saya akan membacakan beberapa peraturan. Pertama, untuk menjaga kelancaran jalannya acara, maka selama pemaparan materi, voice feature harap di-mute. Kedua, untuk pertanyaan dari para peserta, akan ada sesi diskusi setelah pemaparan materi oleh narasumber. Bapak Ibu dapat melakukan raise hand terlebih dahulu, dan silakan berbicara ketika dipersilakan oleh moderator, atau Bapak Ibu dapat menuliskan pertanyaan di kolom chat selama acara berlangsung. Ketiga, peserta diharapkan mengikuti acara hingga selesai karena di akhir acara, panitia akan membagikan link Google Form yang harus peserta isi untuk mendapatkan e-sertifikat dan materi yang akan dikirimkan ke alamat email peserta paling lambat 7 hari kerja. Sir, after the presentation, there will be a discussion session. The participants who could ask several questions and discuss. The participants could send their question through the chat box or just unmute their microphone. Narasumber kita, Mr. Philipp Kersting, beliau saat ini menjabat sebagai Head of Indonesia Desk di Luther Singapore in collaboration with Magdir Ismail and Partners. Beliau menguasai hukum perdata, hukum dagang, hukum perusahaan, penanaman modal asing, merger, dan akuisisi. Mr. Philipp akan memaparkan materi, lalu dilanjutkan dengan sesi diskusi dengan para peserta yang akan dipandu oleh moderator. Mr. Philipp, time is yours.
Thank you very much for the nice introduction. Hello everyone again. I'm honored to be speaking to you today. As I just said, I will speak and present in English. And can everybody hear me well? Because someone in the chat just said my voice was too low.
We can hear you well, sir.
Right. I will come closer to the computer so my voice can maybe be louder.
Okay. Thank you, sir.
I have a general tendency to speak rather fast. If because of that anyone does not understand what I'm saying, please interrupt me or just alert me. I'm used to that, and I will not be offended by that. Please just let me know. As I said, I'm going to present on the German legal and judiciary system. I'm a German qualified lawyer, and I'm very happy to be working with my colleagues at Magdir Ismail and Partners since a long time, and permanently since 2017 when I moved to Jakarta. Today, I will give you an introduction to the legal and judiciary system of the country I'm from. You will see many parallels to what we're used to in Indonesia. And that mainly comes from the type of legal systems that we're dealing with. The next slide, please. So the German legal system is a traditional civil law system. And I know that's basically the same system we have in Indonesia. It's a codified system that takes its origins from Roman law, something that helps me a lot when I try to understand laws in Indonesia, especially in civil law. That's easy for me because I'm used to the same principles. The principles apply across the board, even though the code is sometimes different. As you know, the features of a civil law system include a written constitution and binding for all enactments. And we sort our courts as per the subject matter that they work with, the same as it is in Indonesia. So we have criminal courts, ordinary courts, administrative courts, and so forth. And as is common with civil law systems, because we have a lot of codified law, the principle of freedom of contract is valid, but not as wide as it is in legal systems that rely on precedents such as common law. Next slide, please. Germany has a traditional structure in government that makes it seem very complicated from a legislative perspective. So, and also, even though Germany is widely known as a democratic state, the highest rank of laws are directives and regulations passed by the European Union. And I'm not sure how well aware you are of the legislative structure of the European Union, but technically it is not a clear democratic way of enacting laws. So anything enacted by the European Union stands above national law. That's the big difference between the European Union and ASEAN, where in ASEAN, none of the states has passed on any autonomy to a super governmental body. In the EU, we have very much that situation. So the highest position in our hierarchy is directives and regulations by the EU. After that only comes our constitution. Under that come federal laws. And under federal laws come state constitutions. And then below that is simple law enacted by state parliaments. If we can look at the next slide, we go into the detail of why we have this complicated structure. Yeah. So first, our position in the European Union. After the Second World War, Germany was one of the founding members of the coal and steel community. I'm not sure how familiar everyone is with the history of the European Union, but it started once simply as something like a cartel, where the coal and steel producing and also consuming countries of Europe got together to have more bargaining power on the world market. That was the core of the European Union, with only 6 countries. Today we used to have 27, and now we have 26. As we all know, Brexit happened. We lost one of the bigger members of the European Union. And the reason the UK exited the club was, among others, because they were no longer happy with having to pass on so much autonomy to the super governmental body, which is the European Union. And at the same time, they were feeling like they were a net payer, a net receiver of monies from the EU. It is probably arguable, but it's my personal opinion, and I think it's the vast majority opinion across at least Western Europe, that the European Union is the most important factor in guaranteeing a peaceful and prosperous Europe over the past decades. Among others, the reason why the EU has received the Nobel Peace Prize in the past. Next slide, please. This is just to illustrate where Germany is in the European Union. You may excuse me for not having the map that excludes the UK yet. So this should not be here. But I think the image gets abundantly clear. You see Germany in the middle, the yellow one. And on the right side, you can see all the different states within Germany. So Germany is a federal republic, and that has historical reasons. Just until the end of the 19th century, Germany, as it is today, did not exist. It was just a bundle of kingdoms and small entities that all spoke German, but did not have an understanding of being Germany. And only before the First World War, not long before the First World War, the first time something that was called the German German Reich was formed by all these states. So all these states retain much pride and tradition in being their own state. And as you can see further in the north, there are 3 city-states: Berlin, Hamburg, and Bremen. Those have traditionally been large enough cities to sustain themselves, and they still have the position and prestige of a state in Germany. So we have 16 states, and every state has its own constitution and its own parliament and its own laws. If I may ask you to go one further slide down. Here you can see it again. So we have the central government and then 16 states. The historic reasons I just explained. It used to be like a puzzle of small German entities that then found together in one state. The big difference from, most states have provinces or regions that are governed somehow autonomously, but the level of autonomy that German states have is rather high. So for example, all the states have exclusive jurisdiction over their education and their security, for example. So we have police in every state, but the federal police is only responsible for railroads and border controls. And every single individual state has their own police force. That is the general police force in that state. Sorry. And especially in education, for example, since we don't have central powers on education, their states very much rely on communicating with each other to ensure that even though every state can do their own educational system, all German kids have roughly the same standard when they leave high school. Next slide, please. So the Constitution of the Federal Republic of Germany is a strange animal. It's something that was conceived more by accident than by plan. As you know, Germany was defeated by the Allies in World War II, and then practically divided in 4 sectors: the Russian sector, the American sector, the French, and the British sector. The Western Allies, which were the British, the French, and the Americans, at some point saw it politically feasible to grant all their sectors some kind of autonomy, also politically. But for that, those sectors needed their own constitution. But since the word constitution carries so much force and it sounds so much like a nation, which they didn't want people to have again, because as you know, out of nationalism and fascism in Germany came the Nazi party that brought much trouble over Europe for years. They just decided to call it the basic law, the first and basic law. So we don't have, it does not, so the German word for constitution is Verfassung, but we don't call our own constitution a constitution. We call it the basic law, the basic law. And it was something that was supposed to be a makeshift set of rules for the time being. Luckily, the professors and legal professionals that were tasked with making the basic law, by the way, unusual for the time, quite a number of women were in that group, did such a tremendously good job that this law has survived until today. And something that Germans are very proud of is it is one of the most exported constitutions in the world. So whenever new states form in the world, or states break down and reform, mostly when they rewrite their constitutions, they always consult German constitutional lawyers because they want to learn from the system that was built. And the reason maybe, or quite certainly the reason why the German constitution is so stable is, again, I go into history, and this is quite a detailed fact. Between World War I and World War II in Germany, the country already tried to become a federal democracy, and it enacted a constitution that is known worldwide as the Weimar Constitution. And that constitution had significant flaws in the division of powers and the appointment of officials. And Hitler's Nazi party exploited exactly those flaws in overturning government and establishing authoritarian rule. That's why when the basic law, the Grundgesetz, was formed, they technically went through all the mistakes that they had made before in the Weimar Constitution and made sure that these were not repeated again. Yeah, and as I said before, every federal state has their own constitution. So altogether in the territory of Germany, we have 17 constitutions, 1 federal and 16 state constitutions. We have a parliamentary system of governance in all the states and on the federal level. Most people only know our chancellor. She used to be Angela Merkel for a long, long time, 16 years in power. Now, just recently, a new one was elected called Olaf Scholz. However, the chancellor in the German system is not the highest person in the state. We have a formal president that has no active duties or powers. He's a ceremonial head of state, and as the case is, and it's really a coincidence, the president of the Federal Republic of Germany, Frank-Walter Steinmeier, will actually come to Indonesia in the 3rd week of June, so very soon, as a state guest. The legislative structure is bicameral. So we have the parliament, which we call the Bundestag, directly elected members of the public who enact laws. So that would be the DPR in Indonesia. And we have a federal council that consists of representatives of the federal states. I believe, and please correct me if I'm wrong, in Indonesia, the equivalent would be the DPD. The second chamber, the federal council, Bundesrat, is required so that the federal states cannot totally be overruled in laws enacted by the federal parliament. Next slide, please. Yeah. So, as we know, in a democracy, one of the guiding principles is the separation of powers. And of course, it's a topic in the German constitution, as it is in every one. We separate, of course, the executive, legislative, and judicial powers. It is based in Article 20, column 2 of the Constitution, the Grundgesetz. And we do have what we call institutional breaches of that concept. For example, our chancellor and the ministers who form the government are elected by parliament, so that the legislative power has some final powers over the executive powers, right? So if parliament were to choose to give a vote of mistrust to the chancellor, they could topple the chancellor, even though they're not executive. But those are institutional breaches of power separation that are known to work as checks and balances, so that the one always controls the other, and there's never a concentration of power that is too high. Next slide, please. So in order to make a law in Germany, I will stick to the federal system. Each state then has a comparable state system to enact state laws. the three bodies that can propose laws are the Federal Council, the government, and the Federal Parliament. And then each introduced law has to be read 3 times. So we have 3 rounds of discussions and deliberations on the legal text. And then the laws are passed by a majority of votes cast in Parliament, unless the federal law that is to be passed in Federal Parliament does affect the exclusive rights of federal states. If that's the case, the Federal Council must also approve, because otherwise we have a problem with competence between the federal state and the states themselves. Next slide, yes. So the court structure, I think it's not far away from what we're used to in Indonesia. We have so-called ordinary courts that are responsible for civil and criminal matters. So, but that's not, that sounds like the same court handles the same things. That's not the case. So what we call the Pengadilan Negeri in Indonesia, there are specific courts or groups of judges who handle civil matters, and there are specific groups of judges who handle criminal matters. Then, of course, we have constitutional court on the federal and state level. And for very specialized jurisdictions, I believe it's the same here. That's how I learned it. We have labor courts, administrative courts, financial courts, and social courts. Actually, social courts, I'm not too sure I've heard of that in Indonesia. Germany has a quite large welfare state. So many Germans receive subsidies from the government. And if citizens who receive subsidies from the government feel like the government is not treating them correctly, they can sue the government in a social court. And the high specialty of the social court is that it is completely free of any fees. All fees for lawyers and judges in social courts are paid for by the government, because naturally the people who have to go to social court do not have the financial capacity to pay for a lawyer. Yeah, so another important aspect is how far can the judiciary review legislative and executive actions, right? So there are 2 ways of doing that. So one, me as a citizen, when I'm affected by a measure of the executive that is based on a law, I can challenge that measure in administrative court. And if the administrative court sees that the question that I'm raising is actually affecting constitutional questions, it will be escalated to the Constitutional Court, and the Constitutional Court will find on the constitutionality of the respective law. Or there is a procedure that generally challenges the constitutionality of a law. So if a court has to apply a law, whether it's a federal law or a state law, that the court finds could be non-constitutional, the court can escalate the law itself to the Constitutional Court. And then the Constitutional Court will not review a case and whether or not the application of the law is constitutional in that particular case, but it will objectively review just the law itself for being constitutional or not. Next slide, please. So, due to the unpleasant lectures of the past, especially in Germany, there are certain parts of our constitution that are unchangeable. So the first 20 articles of our constitution are what we call Grundrechte, the basic laws of every person living in Germany. It starts, and the most important one in Germany, especially because of the past, is the right to dignity and to life and to an uninjured body, and those very basic rights that you need to survive. And those can never be changed. So the Constitution gives itself what we call an eternity clause, an eternity guarantee. It basically says there are ways for you to change me, the Constitution, but there are parts of me that can never be changed. That's in order to ensure that any future German government does not go too far, as German governments have unfortunately done in the past. In order to change those parts of the constitution that are changeable, you need 2/3 of the votes in parliament and 2/3 of the votes in the federal council. So a change of the constitution is a very big deal in Germany, as it should be, I think, in every democracy. We just recently did that. Maybe it's interesting as a reaction to the coronavirus and the need for heavy investment in the digitalization of our schools. The federal government, for the first time, took a small portion of the competence on education away from the federal states, the small states, and ruled that certain amounts of the budget were to be allocated to schools to purchase digital equipment for online learning. Yeah, next slide. The binding of lower courts, always good discussions among lawyers. Technically and by the law, German judges are not bound by anything but the law. And German judges are extremely proud of their freedom. And I've practiced in Germany before I came to Southeast Asia, and they do exercise that freedom. So I have pleaded in court, citing cases by higher courts, and I've had lower level judges looking at me and explaining to me that they are free judges as every judge in Germany, and have decided the exact opposite. The concept of precedent is not accepted legally at all. However, especially in what we call mass cases, such as tenancy law, I've worked in intellectual property law a lot. In those areas, we can't say that precedent is valid, but the legal practice is very much formed by prior decisions, and it's almost to the extent as we know it from precedent in common law. Yeah, the question of adversarial or non-adversarial systems. In all civil matters, the system is adversarial, meaning the two parties are they basically take charge of the procedure. The judge is really just presiding over the procedure and making the rules. The judge and courts never investigate. There are some small exemptions in custody cases and some family law matters where courts are supposed to investigate. In criminal matters, we have a district attorney system in which the district attorney must initiate investigations when they have knowledge of certain implying facts. Yeah, the last point is simply that the official investigation principle applies in administrative law. Legal aid is a big question. I included this slide because I used to present, or I'm still presenting a lot with BPHN. You know, as a foreign registered attorney in Indonesia, I'm providing many hours of pro bono education to my fellow Indonesian lawyers. And a part of that I do at BPHN, and they are always very concerned with legal aid. And since when we first discussed legal aid with them, they were so surprised, and we had a good discussion. I decided to include the legal aid slide in almost all my presentations where it makes some kind of sense. And so here it does make sense. In Germany, we believe that your financial status should never ever prevent you from being treated correctly from a legal perspective. So let's say I'm a person of low income and I have a dispute with my neighbor, a rich neighbor. My rich neighbor should not win just because I don't have money to go to court. So if I have a well-founded claim, I can go to a lawyer. The lawyer will look at my case, and when the lawyer thinks it's good enough, at least to be heard in court, he can send his draft claim, the Gugatan, to the court, and the court will only read it, and they won't say if you win or not. They just say, does it make sense or does it not make sense? And if it makes sense, they will pay for your lawyer and the legal fees. And if you lose the case, it will still be paid by the state. So that's how German legal aid works. You can't get legal aid for anything, but pre-approved claims or pre-approved defenses, if someone sues you and you don't have money for a lawyer, pre-approved defenses also get paid by the state. The lawyer gets a legally fixed sum of fees, and everybody has the right and possibility to be represented in court, which I find is a major building block of a truly democratic system, because money should not decide whether or not you are heard in court. Next. Oh yeah, thank you for your attention. Actually, if I ever have the chance to speak to you again, another topic that I found is always worth a debate with my Indonesian colleagues is party financing, because I have found that Indonesia does not seem to have a sophisticated financing system for political parties, which I also find super interesting, because ours is very sophisticated. If we can ever share knowledge about that, I would be happy.
Thank you so much, sir. We are very happy if you want to join our event again in the future, maybe in the next 3 episodes or 2 episodes.
Whatever works for you, of course.
Okay. I'm personally very interested to know more about Germany law, and I'm sure that all participants will do too, because in the chat box there's a lot of questions already appear. We proceed to the discussion session, sir.
Yeah.
Kita lanjutkan ke sesi diskusi. Pertama saya akan buka sesi ini untuk pertanyaan untuk peserta yang ingin bertanya melalui secara langsung. Jadi apabila ada peserta yang ingin bertanya, silakan melakukan raise hand terlebih dahulu. Nanti setelahnya akan saya bacakan pertanyaan yang ada di kolom chat. Silakan apabila ada yang mau berbicara langsung. Okay, probably I'll just read the question in the chat box, sir.
Yeah.
Okay. There's a lot of questions here. I'll go for the first one. Okay.
The English one, right?
Yeah, but he explained his question in Indonesia. Wait, sir. Okay. This question, he also explained it down there. Okay, that's in private law. What's the consequences? Okay, that's probably he means that in private in Indonesia, in private law, Indonesia civil law, when the judge decision does not have executive power, the losing party is not burdened with carrying out the decision, and when he doesn't carry out the decision, the losing party has no power.
Oh, I see. So the question is, if in Germany the losing party does not do what the judge decides.
Actually, the question is if you do not carry out the judge decision, which has permanent legal force, is it a violation or no in German law?
So we have several ways of executing decisions by the courts, right? So if we look at the very simple matter, I would just stick with 2 neighbors arguing, because that happens all the time in Germany. So 2 neighbors argue before civil court about who can use. And the judge decides in favor of neighbor A and against neighbor B. Let's say he decides neighbor A wins and neighbor B has to move his fence to the left, right? If neighbor B does not remove his fence to the left, I, as neighbor A who won, I have several ways of making that work. So I can I can go to court and apply for the losing party to have to pay a fine because they did not obey the court order. And if that doesn't work, our panitras in Germany also have powers to go places and execute. So they would, at some point, the panitra, or is it the panitra? I'm not sure. The people who execute, oh no, that, here it's the jaksa, right?
All right.
Yeah. So, so the jaksa would at some point come with the police and people who, and construction workers, and really remove the fence. So we escalate in how we punish someone who doesn't comply with civil judgments, but at some point it will just be enforced.
Okay, thank you, sir. We will move to the next question. Okay, it's actually about the EU itself.
Okay.
The question is, why did the UK leave the EU, and is Turkey in EU or not? And why is it happen?
Right.
Probably.
Both questions could fill a whole day. It's very political. I will maybe just try to be very objective.
Okay.
I mean, as a German, I'm very European at heart, so I will never understand why the UK left the European Union, but that's their problem. The UK basically left because they felt that they were making many high payments to the European Union, but not receiving enough benefits back. So the strong economies in Europe make tremendous contributions in money to the European Union. And then the European Union decides how to use those subsidies to help countries within the Union that have weak structures and that need financial support to catch up with the others. For example, all agricultural states in the European Union receive high subsidies. And Britain felt, or the UK felt, that they were a net payer. Germany also is a net payer. I think France is a net payer. All the big economies pay more than they receive back because we help the economies that still need to catch up to the big ones. And yeah, the UK simply felt that it was no longer a good deal for them. That's why they exited. Also, they were rather late to join. And that has historic reasons. There might have been a little bit of sakit hati left in the UK because they tried to join twice and they were both times blocked by France. So somehow you could say that maybe the public opinion in the UK always felt like they never really belonged to the club. And that's why it was easier for them to leave. The case of Turkey is something that is very close to my heart. I come from Hamburg in the north of Germany, and we have very many Turkish immigrants there. I grew up among lots of Turkish friends, and I mean, many of my Turkish friends are now judges and lawyers in Germany, so they are German nationals, but they come from Turkey. And as you know, Turkey is directly on the border between Europe and Asia. It's a very interesting spot on earth, and there's so much European in Turkey, and there's so much Asian in Turkey. I would have been a huge fan of Turkey being a part of the European Union, not just strategically, but also because the normal effect of countries becoming part of the European Union is that they do initiate. I was just muted. Am I audible now?
Yes, sir.
Okay, good. The usual effect of people joining the European Union is that they make huge steps forward in democratization, reduction of corruption, and all this. And I think Turkey was on a very, very good path. Right now, it doesn't look that way. But I think it was this is just my very personal opinion. Okay, not every European thinks that way. My personal opinion is it was wrong to take the candidacy status away from Turkey. I think if Turkey had the prospect of joining the European Union one day, they would be orienting towards Europe more than they do right
Okay, thank you, sir. Next question is, there are 17 states that have their own legal codification in German. Are the codification in each state are the same as the regional regulation in Indonesia?
I have to say I'm not sure. But I think that the regions in Indonesia do not have the same autonomy as the federal states in Germany. But I'll happily be educated in that. I'm not too familiar with that concept. Maybe it's easiest again to explain it historically. So historically, 1945, Indonesia was born as a nation, right? So Indonesia was born as the nation it is today with the borders it has today, right? Germany, and before that, Indonesia was occupied by an enemy force, right? So Germany, on the other hand, was not occupied or colonized. It was simply just very many states who felt like they were their own boss, right? So, and then they all got together to form, just like the United States before, right? They all got together because they thought they have a better chance of getting together. And that's why the identity of every single state is still very important to them. And that's why they all still retain their own constitution and very much competency in governing aspects of their, in their own territory.
Okay, sir. We got it from the historical perspective.
Yeah.
Okay. Next question is, okay, I don't know, is it a good answered question or no, but the question is, why are regions or province in Indonesia didn't driven by their own constitution like in Germany?
Yeah. So I think it aims at the same points I just explained. Yeah. But for example, I think, I mean, it's not supposed to be criticism of the current system in Indonesia, but Indonesia as a country is much more diverse than Germany. Religiously, ethnically, language-wise, you are so much more diverse and so much bigger. Right? So in Germany, for example, I come from the north, and the north is typically Protestant Christian. The south is typically Catholic Christian and has a very different culture. And you can see the history of those cultures in the individual constitutions of the states. And in Indonesia, I think, even though the constitutions would probably not be significant in a legal sense, because they would have to, at the end of the day, every German state constitution must be in line with the federal constitution, not be completely different. And otherwise the system wouldn't work. But having their own constitution, or whatever you want to call it, in every region in Indonesia would probably add to the feeling of identity as a diverse region of a big country. Right? So I don't think there's anything wrong with constitutions in every single state. In Germany, to be honest, the constitutions in the single states do not play a big practical role. It's more of a cultural thing. I mean, there are effective laws. And if, for example, if I'm a citizen of Hamburg, and I feel like I've been mistreated by the police in Hamburg in a way that affects my constitutional rights, I would first have to go to the Hamburg Constitutional Court, because the police is a federal state matter. And if they violate my basic rights as a human being, the initial constitution I have to take into account is the federal state constitution, and only thereafter we would go to the German constitution.
Okay, we'll continue, sir.
Sure.
The next question is the bicameral system in Germany is the same as the bicameral systems in Indonesia in the context of the legislature?
Maybe you can help me. I do believe or anyone in the audience, please, the representation of the federal states in Germany, just as the representation of the daerah in Indonesia, is meant to make sure that legislation on the central level does not miss aspects that are important to the daerah, right? So however you intersect the two is different in the two systems. But the fact that you say, I have a bicameral system, the first chamber is elected representatives of the people, because the momentum of the law should come from the people. And the other one is elected members who represent the regions, because you have this effect. We have the same in Berlin, and I'm sure it's the same in Jakarta, of political culture forming in parliament and not always being totally aware of the needs and the reality in the regions, right? So maybe I'll make a radical example. People who've lived in Berlin their whole life and have had no job but to be a member of parliament have absolutely no clue how their decisions affect the most eastern part of Germany where we border with Poland, right? Because they simply don't know anything about that. So when they make those decisions, I think it's right that representatives from those parts of Germany that are not known to everybody have a chance to double check whether that's in line with their needs or whether that violates their needs. So the bicameral system, especially in a diverse country like Indonesia, I think makes a lot of sense.
Mm-hmm. Okay, sir. Next question is, in Germany, would you read this, sir?
Oh, it's in German. Yeah, I thought that was someone.
From Mr. Bayu.
Okay, Mr. Bayu, first of all, wundervoll, dass Sie in Deutsch schreiben. Dankeschön. So the question is not absolutely clear to me. I'll try to rephrase it. What is a significant aspect that makes a difference between the German system and the continental system generally? Right. I will reinterpret the question, and Mr. Bayu, please just raise your voice if I go wrong. So I think what you meant is what makes it, what is the biggest difference between the German federal system and the central government system?
Danke.
Sehr gerne.
Guten Tag.
Guten Tag.
Yeah. Ini lebih ke hal mendasar. Apakah Jerman sebagai negara yang merupakan Continental berbeda dengan Prancis, atau bagaimana peranan kanselir atau perdana menteri dengan presiden?
I think I understand. So the two best examples of how different you can govern a country in Europe are Germany and France. Germany has a very federalistic system, whereas France has a very centralistic system. In France, basically every main decision is made in Paris. And even though France has significantly more diverse regions in terms of food and traditions than Germany, France has always been France. It doesn't have that history of small states getting together. It has always been a huge kingdom. And the central government of France has so-called prefects in all the regions. So while there are local governments, they simply execute decisions from Paris in the regions. But the regions have much less autonomy in how they govern themselves. So France has a very sophisticated system of making sure that central decisions are implemented in a way that the regions all benefit from them. Whereas Germany has a system that doesn't even allow the central government to take decisions in certain aspects because only the regional governments can make those decisions. For example, police and education.
Okay, there's 2 more questions, sir.
Yeah, sure.
It's from Mr. Sam.
Yeah, I have read it.
Okay.
Yeah. So the question is, well, first of all, Mr. Sam is thanking me. It's my pleasure. Thank you for having me. And the question is, in Indonesia, in order to ratify the United Nations conventions, we need a resolution from Parliament. And the question is, did the German Parliament ratify or approve?
Hello.
So the question is, in order to join the EU, did German Parliament approve? And I think it's a very good question because, as I mentioned before, Indonesia didn't even pass any national autonomy to the United Nations, right? Indonesia simply made itself subject to universal laws that the United Nations deem applicable to all countries in the world. But the European Union goes significantly further than that. So once you become a member of the European Union and you decide to give powers that are your autonomous powers as a state to the European Union, that's very significant because you lose those powers for as long as you're a member of the European Union. So not only, of course, did the German Parliament approve to become a member of the European Union, but also it changed the constitution of Germany. We have certain articles in our constitution that we call the European articles, because in order for Germany as a country to be able at all to pass on autonomous powers to a super governmental institution like the EU, that had never been done before, right? So we needed legislation inside the constitution to make sure that there was a way for Parliament at all to pass on those powers. And the German constitution does it in a way that they say we cannot give a blank approval to pass on powers. Every single detailed power that we pass on must be approved in detail by Parliament. So we can't just say, okay, whatever the EU wants, we give it. Whenever the EU wants to enact a guideline that affects a certain type of autonomy in Germany, that autonomy, in case it has not been passed on to the EU before, has to be approved again. So we are very careful about passing on our autonomy to the EU, and that's why we need Parliament's approval every single time.
Okay, thank you, sir. And the last question is also written in English. May you read it, sir?
It's in German, you mean?
No, it's in English. Or I could read
the
it.
Advocate Organization?
Yeah. Yes.
Oh, yeah. So, again, I hate to say federal state so much today, but we only have an umbrella organization of advocate organizations. It's called the Bundesrechtsanwaltskammer. The translation is the Federal Chamber of Advocates. And then every federal state has their own organization of lawyers. And I, for example, I'm an acting member of the Hamburg State Bar. And I have friends who practice a couple of kilometers on in another federal state. So they are members of another state bar. And way before I became a lawyer, if you were a member of a state bar, you were only allowed to practice law in that state. So I would have only been able to practice in Hamburg. And if I would have had a case in Berlin, I would need a correspondence lawyer in Berlin. But in the early 90s, that restriction was lifted. So it doesn't matter anymore. Where in Germany, you're a member of the bar, you can practice in any court.
Okay, thank you, sir. Actually, there's one more question, sir. Is it okay?
Yeah, we still have time.
Okay. The question is, how is the constitutional compression of presidential impeachment arrangement between Indonesia and Germany?
Okay.
About impeachment.
Sure. I also see a raised hand with Mr. Hidayat.
Yeah.
I only see like 5 of us, so I can only see one raised hand. In Germany, there is no, we don't call it impeachment. Traditionally, we call it a vote of non-confidence. Whenever more than half the parliament does not support the chancellor anymore, he's done. So the chancellor has immunity against criminal investigations, but the parliament can lift the immunity if it's about criminal matters. And of course, if a chancellor is convicted, then he can no longer act. But even if it's not a crime, if people simply deem the chancellor unfit or no longer fit or not as the right person to rule a certain situation, usually what happens is that some members of his own party will vote against him, and then he will have to step down. So also in Germany, I know that's nothing new for Indonesia, but Germany traditionally has had coalition governments. So we rarely have only one party ruling the country. Right now, it's a coalition of 3 parties, which is quite the exemption. Usually it's a coalition of 2 parties. And usually it's enough for one of the 2 parties to no longer support the chancellor and to team up with another party, and then the chancellor is done. Very famously, that happened with Willy Brandt, one of our previous chancellors. He received a vote of non-confidence and was succeeded by Helmut Kohl, who then proceeded to govern the country for 16 years and was the chancellor when Germany was reunited in 1990.
Thank you, sir. Maybe Mr. Hidayat.
Oke, thank you. Mbak siapa nih namanya? Mbak Inas ya?
Ya, Pak.
Oke, good afternoon, Sir Philipp. As a member of Magdir Ismail Law Firm, are you handling case in Indonesia too?
So, as you know, as a foreign registered attorney, I'm not allowed to appear in court. And I'm also not allowed to advise on Indonesian law by myself, right? So my function in the law firm is I am part of a collaboration between Luther LLP, which is the Singaporean office of a German law firm, and Magdir Ismail and Partners. So what we do is many German clients have problems in Indonesia or want to set up a company in Indonesia. And I basically act as someone who can explain to the German client what the difference is between Germany and Indonesia. But the knowledge on the details of Indonesian law all comes from my Indonesian colleagues. So they explain to me what's happening in Indonesia. Let's say, for example, we want to obtain a migas license for a German client, right? Then my Indonesian colleagues explain to me how it works in Indonesia, and I am able to explain it to the legal department of the German client because I know how they see the law, because I learn it the same way. So it's basically me adding the German knowledge to the Indonesian team so that we can perfectly serve a German client.
Okay, I see. The last question, Miss Inas,
Okay.
or Sir Philipp. Maybe you can spill how much money do you have in handling case in German? This is Philipp.
You mean how much a lawyer makes when handling a case in Germany?
Yes.
So in Germany, we have a quite sophisticated system of minimum lawyer remuneration. So if we stick with civil cases, right? If I'm a lawyer in Germany, I used to be a lawyer in civil cases in Germany, and I agree to represent a client for the basic fee as per the law. there's a huge long table of how much is the case worth and how much do I get for handling the entire case. Or I can agree on an hourly basis. But the hourly basis is usually more expensive. So for example, what I said in the beginning with the legal aid, right? If the state provides legal aid, the attorney always only gets paid what is owed to him by the law, never hourly rates or anything like that. But I have to say, even what is owed to the attorney by the law is definitely enough for the attorney to survive. It's good income.
Okay, sure. Thank you.
My pleasure.
Oke, terima kasih Pak Hidayat. Selanjutnya mungkin there's one more person that raise hand, sir.
Sure.
Pak Muhammad, silakan Pak.
Oh, masih mute.
Pak masih mute. Pak Muhammad, maaf Pak, masih di mute.
Why England or British Imperium quit from the European Union? Why?
Okay.
Why they quit from the European Union? Is
Yeah.
it because of Eurifa in World War II or whatever? The reason, I don't know. The second reason, the second question is in Germany, all of the people in Germany really realize the importance of lawyer. So there is no poor lawyer. I mean, lawyer without any income, you know, like LBH, something like that.
Yeah.
Lembaga bantuan hukum. Sometimes lawyer in Indonesia have no cases. So people just ask their aid, but no payment for the lawyer.
Mm-hmm.
The second question is that, is German really good country? So the professional lawyer is very important, yeah? That's only two questions only. Thank you.
Thank you very much for your questions. I will start with why the UK left the EU, because we had that question earlier already. There's hundreds of reasons for that, of course. I think there are political reasons, financial reasons, and also cultural reasons. So UK is an island outside of Europe. They have always felt special. I don't know if the term splendid isolation means anything to you, but in any conflict between continental Europe and the US, the UK has always proudly been isolated and not a party. And the UK had tried to join the European Union twice and was rejected because of a veto by France, and then finally got in not too long ago, actually. And it seems like the people of the United Kingdom never warmed up to the idea of being part of continental Europe. So I think it's mostly a cultural thing, but also it's something that it was very much the trend of the time. Not just the UK was thinking about quitting the European Union. I remember the Dutch were thinking about it, but then overwhelmingly voted against it. And the UK did it, and I think they lost much of their access to the European financial markets, which was a huge driver of the success of the London banks. To be honest, there are findings that if only the young English had voted, they would have voted to stay. But there's a big traditionalism among the UK population, and that prevailed. So for now, they will not be part of the club. We will see how that works. And, on your second question, luckily I've practiced law in Germany before I came to Southeast Asia to support German clients. And I can say, I mean, this sounds a little rough, but you know, in Germany definitely provides an environment in which, as a lawyer, you can succeed easily if you work hard. So, for example, when I stopped my university education to become a lawyer, I already had a law firm that I wanted to work for because I was specialized in copyrights. But I have a lot of friends who had no specialization and who became criminal attorneys. And all they did was they went to jail and sat down in front of the jail and waited for people from jail who were sent from jail to the court, went up to the guys and said, hey, I know you're going to court. You're going to need a lawyer, because they know exactly that if the guy says yes and the court appoints them as the attorney, they will get paid by the government. So if you are rajin, as we say in Indonesia, definitely Germany provides an ecosystem that you can strive and very much grow in as a lawyer, even if you don't have a job right away out of university. It does work.
Sorry, the last question, yeah?
Mm-hmm.
The last question from me. Do you think that the political theory of Montesquieu, where you divide it into legislative, executive, and judicative, really conducted in a very good consequence? I mean, in Indonesia, sometimes the executive power too heavy, but legislative power not so heavy.
Yeah.
And also, judicative power sometimes directed by executive power. So something like political order from the president or from the minister or from the military. Now in Indonesia, sometimes we find so many corruption cases because of political order, not really about corruption. Now in Germany, under the chancellor, the woman who are very great, she is a very great woman. Do you think that Germany is very stable in this or not?
I think there's no real answer to that question, but I can definitely confirm that, or in my personal opinion, the division of powers is key to every rule of law to work, right? So if you don't have division of powers and they cannot check and balance each other because one is stronger than the other and has influence on the other, then the whole idea goes wrong. And for me personally, I have to say, if you look at what we as lawyers, our daily work in Indonesia is we always look into regulations, right? We not so often look into laws, and it should be the other way around, because laws are enacted by parliament and regulations are issued by the executive. So even the way laws are made in Indonesia grant very high powers to the executive, because the executive then has the power to issue the implementing regulation, right? And so there's definitely a breach in the separation of powers already there. And it does not surprise me that there are more breaches in that. And I think only if you manage to separate those very strictly, you can have a working rule of law.
Cukup, Pak Muhammad?
I think he's interrupted.
Hello?
Oh, yeah.
That's him.
Hello, sir.
Can you still hear me?
Yeah, I hear you now.
Did you hear my answer?
Continue. Yeah, continue, please.
Can you tell me where you lost me?
Yeah, the last one. Last 1 minute.
Okay, so
I lost your voice.
I will just summarize it. So I think that if you cannot very strictly divide between the three powers, you will not have rule of law.
Okay. Yeah. Thank you very much for your answer.
Sure, my pleasure.
Okay, thank you, sir.
Pak Muhammad, mungkin nanti bisa dilihat rekamannya juga di YouTube.
Okay, siap.
Oh, yeah.
Okay, I think that's the last question, sir.
Okay.
Thank you, Mr. Philipp, for the discussion. Bapak Ibu sekalian, demikian acara Legal Upgrade episode 9. Bapak Ibu dimohon untuk mengisi form sertifikat yang telah dikirim oleh panitia di kolom chat untuk mendapatkan sertifikat dan juga materi. Selanjutnya akan ada sesi foto bersama. So, next is the photo session. Kepada seluruh peserta, silakan mengaktifkan video. Yang belum, silakan dinyalakan. Baik, ini ada 2 slide. Slide pertama, first slide, 1, 2, 3. Oke, slide kedua, 1, 2, 3. Baik, terima kasih. Sebelum kami menutup acara hari ini, kami mengucapkan terima kasih sekali lagi kepada Mr. Philipp yang telah memberikan banyak ilmu baru pada kita semua. Maybe in the next 2 episode or 3 episode, we will invite you again, sir.
Anytime.
Okay. Dan kami juga mengucapkan terima kasih banyak kepada Bapak Ibu peserta atas partisipasinya dalam kegiatan Legal Upgrade hari ini. Kedepannya kami akan mengupload rekaman Legal Upgrade di kanal YouTube DPP Ikadin. Saya selaku moderator pamit undur diri. Terima kasih atas partisipasinya. Kita bertemu lagi dalam Legal Upgrade episode 10. Informasinya akan kami sampaikan melalui akun Instagram Ikadin. Terima kasih, selamat sore, salam sejahtera. Wassalamualaikum warahmatullahi wabarakatuh. Thank you, sir.
Thank you.
Waalaikumsalam warahmatullahi wabarakatuh.